Good afternoon, everyone, and welcome to our webinar on recognition and enforcement in insolvency proceedings from an onshore and offshore perspective. My name is Christina Holiday, and I'm the marketing manager and BD manager of Hamdan Al-Shamsi Legal. This webinar is delivered by Hamdan Al-Shamsi, senior partner and founder. Unfortunately, Robert Whitehead couldn't make it today. But we have our partners from the UK, Alex Cook, Zara McLone, and Carl Anderson, barristers from Four Stone Buildings, who will be delivering the webinar along with Hamdan. Please note that the following presentation will be recorded, and it is purely for educational purposes. It may be shared on social media. For all your questions, please share them on the webinar chat, and we will be able to answer them at the end of the webinar. Now I will hand it over to Hamdan, who will start the webinar. Thank you so much for your attention. Welcome, Hamdan.
Thank you, Christina, and welcome to everyone who's joining us today. We will be looking at insolvency proceedings. And insolvency proceedings are becoming increasingly more important following the coronavirus pandemic. And the law governing insolvency proceedings in the UAE, both onshore and offshore, is still developing. A large part of this webinar focuses on the recognition of foreign insolvencies and the way cross-border insolvencies operate in the UAE. As the world is becoming increasingly more international and companies work across more and more countries, the matter of cross-border insolvency is becoming much more important. There'll be some interesting examples and cases we'll be looking at, in particular the recent decision of NMC Healthcare, which highlights the importance and differences between onshore and offshore regimes, and the Dubai Court of First Instance decision in the matter of the liquidation of the company Marca, which was an important judgment in respect of directors' liability in the context of corporate insolvency. The purpose of this seminar is to identify key features of the onshore and offshore insolvency regimes, especially in relation to the rules of recognition in foreign insolvency procedures, where the differences between the two regimes are the most stark. I'll pass on to my colleague Carl to start off the offshore perspective.
Thanks very much, Hamdan. So when we're talking about the offshore perspective, what we're really focusing on here are two jurisdictions, being the DIFC and the ADGM. And in respect of both of those jurisdictions, there are sophisticated insolvency rules and regimes in place. In the DIFC, we have Insolvency Law number 1 of 2019 and the accompanying insolvency regulations of that year. And in the ADGM, you have the Insolvency Regulations 2015, which were amended in April of last year, and the accompanying Practice Direction 14. Now, as I said, those rules contain detailed provisions as to the variety of insolvency procedures that can be engaged in those jurisdictions. For example, winding up of companies, either on a compulsory or non-compulsory basis, and administration as well. It's worth pointing out at the outset that the dates of those regulations in both the DIFC and the ADGM highlight the fact, in our view, that both of these offshore jurisdictions take these rules about insolvency seriously, and that they're committed to ensuring that as offshore commercial jurisdictions, their rules on insolvency are developed and updated in accordance with prevailing international and prevailing commercial practices. So to take the ADGM as an example of that, the 2021 update to the insolvency rules there included some streamlined procedures, for example, to help with the filing of documents in those types of proceedings on the ADGM's e-courts platform. But also more substantively, there was an entire new set of rules introduced in that update, which allow now administrators to obtain priority financing in the ordinary course of business from unsecured lenders. So in short then, these are sophisticated rules in both of these jurisdictions, which have been developed and are still developing to help creditors, debtors, and insolvency office holders alike in navigating insolvency proceedings in those jurisdictions. So turning to one of the focus of today's seminar, which is the question about recognition and enforcement of foreign insolvency proceedings. The main point to start with here is that both the DIFC and the ADGM insolvency regimes adopt the Untitled model law on cross-border insolvency, which essentially means that foreign insolvency office holders, such as liquidators and administrators, can easily apply in the ADGM and DIFC to have their own insolvency procedures recognized in those jurisdictions. And just pausing there, it's worth pointing out that the Untitled model law is still being adopted by countries to this day. It's now been adopted in 55 different jurisdictions around the world, with 3 jurisdictions having adopted it as recently as 2020. So it's likely that a lot of what we discussed today in respect of the benefits of recognition and enforcement in the DIFC and the ADGM will similarly apply in jurisdictions such as the UK, the USA, Australia, New Zealand, etc., where the Untitled model law has also been adopted. Turning back to the recognition of those proceedings in the DIFC and the ADGM, the key starting point is to note that the foreign insolvency proceedings will either be recognized as foreign main proceedings if the company has its center of main interests in the DIFC or ADGM, or else as foreign non-main proceedings. And there is a presumption in both the DIFC and ADGM rules that a debtor's registered office will be their centre of main interests, and the jurisprudence in relation to working out centre of main interest is well known to most who practice in this area. The principal difference between recognition as foreign main proceedings and foreign non-main proceedings is that in the case of foreign main proceedings, there will be an automatic moratorium which prevents all litigation or execution against the debtor in that jurisdiction. On the other hand, if you're in the territory of foreign non-main proceedings, what the office holder needs to do is actually bring an application to the court to obtain a similar moratorium and a stay on execution and on the commencement and continuation of proceedings in that jurisdiction. Now, that's obviously a common application for office holders to make, and it can, in practice, be combined with applications for other orders, which we'll come on to look at shortly as well. So that's the starting point for recognition. Applying for recognition itself in the DIFC or ADGM is a pretty straightforward process, and it comes with extensive advantages, particularly for the insolvency office holder. And that's all part of the stated purpose of the Untitled model law, which is to help enable cooperation and coordination between international jurisdictions on questions of cross-border insolvency. So just turning to a few of the advantages that recognition and enforcement leads to. The first of those is the moratorium itself. Now, the moratorium, whether it arises automatically or on the basis of an application, will apply not only to litigation that has been initiated against the debtor, but also to execution processes that have been initiated or will be initiated against the debtor's assets in the jurisdiction as well. So in those circumstances, recognition represents a very useful tool for insolvency office holders in ensuring that any assets of the debtor which are located in the DIFC or the ADGM are essentially preserved and ring-fenced for the benefit of the office holder's duty to distribute those assets to the creditors. And related to that is a separate advantage, which is that one thing that the office holder can do in both the DIFC and the ADGM is to apply for interim relief, staying execution against the debtor's assets, whilst their application for recognition is pending. So this is particularly useful if there is a risk that the office holder thinks that assets might be improperly dissipated once the debtor learns of the office holder's intentions. It essentially allows the office holder to ring fence those assets in the interim and prevent them from being dissipated before recognition has formally taken place. So those are also very useful mechanisms that are in place in the ADGM and the DIFC. The second main advantage of recognition in those jurisdictions is that the office holder has a right to apply to both examine witnesses and to obtain the delivery of information concerning the debtor's assets. So in those circumstances, recognition is actually a helpful tool for information gathering. And that will be particularly useful if the office holder needs information as to the location or the value of the debtor's assets, and they're currently unknown to the office holder. And the third and final advantage of applying for recognition in these offshore jurisdictions is that upon recognition being granted, the office holder obtains the right to initiate any action under the provisions in the DIFC and ADGM governing claims for transactions as an undervalue and preferences and those types of claims. And that is a significant power, which essentially allows the office holder to take steps to claw back assets and recover property which has already been wrongfully put out of reach of the creditors. So in other words, recognition has distinct advantages at each stage of the office holder's inquiries. They can ring fence assets before they're recognized. They can obtain information about those assets once recognition has happened. And if there has been an unlawful dissipation of those assets, they can take steps to try and recover those. So these are sophisticated rules that really do lend themselves to office holders bringing applications for recognition and enforcement. So on that note, I'll now hand over to Zara, who's going to talk about a high-profile case of recognition and enforcement in the area, which is the NMC healthcare decision.
Thank you very much, Carl. As Carl indicated, I'm going to be talking about the NMC healthcare case. Now, starting off with some background, NMC Health is a healthcare chain and distribution business. Some of you will know it was the largest provider of private healthcare in the UAE. The group was listed on the London Stock Exchange in 2012. And in fact, it was the first UAE-based business to be listed in the premium section of the official list of the LSE. Now, on the 17th of December 2019, an investment firm, Muddy Waters, which is known for short selling, published a report into NMC. And that report raised various questions about NMC's accounts. Following the publication of the report, NMC Health PLC, which was the group's topco, announced to the market that it had discovered the existence of supply chain financing arrangements which had not been disclosed to or indeed approved by the board. There were further investigations, and these led to the discovery in March 2020 of undisclosed debts of over $4.5 billion US. And this then led to the appointment of administrators by the English High Court over NMC Health on the 9th of April 2020. That appointment was made on the application of Abu Dhabi Commercial Bank, which is one of the group's creditors. And in June 2020, the US Bankruptcy Court in the state of Delaware granted recognition to the English administration as the foreign main proceeding. The ADGM and DIFC decisions, which I'll come on to shortly, concerned certain of the NMC companies which were owned either directly or indirectly by the English company. But those companies were all limited liability companies incorporated onshore in Abu Dhabi, Dubai, and Sharjah, which meant that they weren't within the jurisdiction of the English courts and therefore not part of the English administration process. And so the decision was taken later in 2020, to re-domicile those companies in the ADGM. The mechanism for re-domiciliation is set out at Chapter 2 of Part 7 of the ADGM Companies Regulations. And the starting point is Section 100, which provides that a body corporate which is incorporated outside the ADGM may apply to the registrar for the issue to it of a certificate that it continues as a company registered under these regulations. It's important to note, for present purposes, that the company must be solvent. Section 101, subsection 3, provides that a body corporate cannot make such an application if it is in an insolvency situation. The logistics of making an application are set out in part at Section 102, which sets out the documents which have to accompany an application to the registrar for continuance within the ADGM. And those documents include a statement of solvency, which is to be in the form required by Section 114. Section 105 of the regulations contains the criteria which the registrar has to take into account in determining an application for continuance within the ADGM. It's worth bearing in mind that this isn't an especially arduous process. The criteria include, for example, that the body corporate is eligible to make such an application. And the result of a certificate of continuance being issued is set out under Section 107 of the regulations, which provides that the body corporate becomes a company registered under the company's regulations, to which those regulations therefore apply. And in the NMC case, those companies each applied to the registrar to be registered in the ADGM on 15th, 16th and 17th of September 2020, which is when the registrar both approved those applications and issued certificates of continuance for those companies, which meant that they were effectively transformed into ADGM companies, having been initially incorporated onshore. This re-domiciliation provided the NMC companies with standing under Section 8 of the ADGM Insolvency Regulations, so that they could apply for administration orders. And it also meant, of course, that the ADGM court had jurisdiction to hear and decide those applications. And those applications were heard by Justice Sir Andrew Smith on the 27th of September 2020. And the criteria for the court to make an administration order are set out at Section 7 of the Insolvency Regulations. And they provide that the court has to be satisfied first that the company is or is likely to become unable to pay its debts, and secondly, that the administration order is reasonably likely to achieve the purpose of the administration. The judge granted the NMC companies applications for the appointment of administrators, finding that both the cash flow and balance sheet tests for insolvency were satisfied. Now, the judgment doesn't seem to explore the fact that the administration applications were made a matter of days after certificates of continuance had been granted in respect of these companies. And so the applications had been made a very short time after the NMC companies had had to provide statements of solvency. But it seems that the short answer to this is that where the relevant entities had been re-domiciled in the ADGM, that was a done deal, if you like, the court didn't need to consider this point. And it may be the case that the cash position of the companies was just sufficient to enable them to provide statements of solvency at the time when they applied for certificates of continuance. It's also worth noting that submissions were made at the hearing of the administration applications on behalf of 7 lenders who were creditors of the group, but none of them seems to have actually taken a point on this timing. In any event, following the re-domiciliation of the NMC companies in the ADGM and the appointment of administrators over those companies by the ADGM court, the DIFC court granted an application for the recognition of their appointment in the DIFC. That order was granted by Justice Wayne Martin on the 11th of November 2020, and it provided for the recognition of the administrator's appointment and for the active assistance of the DIFC courts, in particular, to stay proceedings against the companies in the DIFC courts. It also provided for the enforcement of the ADGM administration order pursuant to the rules of the DIFC courts, and specifically Rule 45.8. And this permitted the administration order, which had been made in the ADGM, and the terms of that order to be capable of enforcement in the DIFC as a non-money judgment. Following the orders granted by the ADGM and DIFC courts, the joint administrators were able to implement the administration procedure, which provided the NMC companies with the protection of a statutory moratorium. And so, tying this all together, the NMC health case is a useful illustration of how the ADGM rules can be used essentially to transform an onshore entity into an ADGM entity, such that the new entity is subject to regulations in the ADGM, which can have further direct and indirect effects in an insolvency situation. Of course, redomiciliation is not an unusual concept in and of itself, but given the landmark nature of this case in the Gulf region, it remains to be seen whether it will have any more far-reaching consequences for other parties, and if so, what those consequences may be. But in any case, the use of redomiciliation in the NMC health case paves the way, at least in theory, for this mechanism to be used in future insolvencies where onshore UAE entities are concerned, although of course there may always be difficulties where those insolvencies are contentious. And I believe Alex is going to add a couple of thoughts to what I've just said. Alex.
Yes, thank you, Zara. I just wanted to touch on two further points following on from what Zara has said about the NMC healthcare decision. The first is, as Zara mentioned, NMC Healthcare was able to re-domicile into the ADGM. But as she also mentioned, one of the requirements of the ADGM company's regulations is for a statement of solvency to be provided. Now, that requires a director to state that the director reasonably believes that the company will be able to discharge its liabilities as they fall due upon the issue of a certificate of continuance. Now, one does wonder how that's going to be possible in many cases where there may only be days between the redomiciliation and the administration order. So the requirement for a statement of solvency could well be an obstacle in future cases where redomiciliation is sought, especially in contentious insolvencies. So for example, if any creditors oppose the intended administration, we may see such creditors take a more active role in opposing a request for redomiciliation at the earlier stage. The second thought was really just to highlight the use of the ADGM administration order. What happened after it was obtained was that the administrators were able to take that decision and have it recognised by the English High Court as foreign main proceedings under the English cross-border insolvency regulations. Now, there are a few interesting points to note about Sir Alistair Norris's judgment in that case. Firstly, the English court was satisfied based on certified copies of the sealed judgment and order of the ADGM court that they were a foreign proceeding and that a foreign representative had been appointed within the meaning of the cross-border insolvency regulations. The English court also looked at the nature of the ADGM order and was satisfied that those proceedings were, among other things, proceedings in which the affairs and assets of the debtor are subject to the control or supervision by the foreign court for the purposes of reorganisation or liquidation. The judge also went on to consider whether the proceeding should be recognised as a foreign main proceeding, which requires the proceeding to be taking place where the debtor has his centre of main interests. Now, because NMC Healthcare had re-domiciled to the ADGM, it was presumed under the regulations that it had its centre of main interests in the ADGM, where its registered office now was. And in this case, there was nothing to rebut that presumption, and accordingly, the judge was satisfied that he ought to recognise the administration as foreign main proceedings. So what this decision shows is the willingness of the English court to give effect to insolvency proceedings opened in the offshore courts of the UAE. Although that being said, the application to the English court doesn't appear to have been contentious, nor did the court hear any contrary submissions. So it remains to be seen whether future attempts at onward recognition will be so straightforward. So that completes our brief review of the offshore insolvency perspective. I'd now like to hand over to Hamdan, who's going to speak a little bit about the onshore insolvency regimes. Hamdan.
Thank you, Alex. Redomiciliation is certainly an interesting part of the NMC insolvency. So from the onshore perspective, the insolvency procedures are really governed by two main laws. And for corporates, it's the 2016 law. And for individuals, it's 2019 law. So they're quite recent laws. And there's a lot of case law that has been issued by the courts in the UAE to test those new laws and see how they're applied by the courts. And the laws modernize the onshore insolvency process, has introduced familiar concepts of third-party trustees whose roles are to liquidate the debtor's assets, as usual. But starking enough, there was a recent judgment, which is very interesting, which is the Marca judgment that I mentioned previously. And in this case, the courts held that the board of directors and managers were responsible for the creditors for the creditors and outstanding debts against the company, which is in a region of 450 million. The board of directors essentially were responsible for the company's debt. And he relied on, well, the judgment relied on Article 144, which mentions that if a court finds that a company is bankrupt and the company is unable to pay 20% of its debt, it could obligate or compel the board of directors to be liable for those amounts. And of course, there has to be certain breaches committed by the board of directors, which, according to the trustee or expert appointed by the courts, he's found them to have breached those laws. And whilst the bankruptcy is still ongoing, we're yet to see a final decision in respect of those matters. What's interesting as well is that the law on bankruptcy, corporate bankruptcy 2016, and also the commercial companies law also has a lot of provisions in respect of the responsibility of the board of directors. One of which is to keep good commercial books in place to reveal the company's financial position. So in a company as big as Marca, or for that matter, any other company, it seems to be very important for the board of directors to ensure that the company's commercial books and accounts are kept in order, not just from a CFO or their accounts department. In addition, from the commercial company's perspective, the board of directors can be responsible to third parties and creditors of the companies if they misuse power or violate provisions of the law or any acts which contravene or breach the articles of association of the company. So a board of director or manager acting ultra vires. In the Marca decision, the Dubai court held that the directors and managers were liable under those articles mentioned, and along with other articles under the law. They were held personally responsible for the amount that the creditors owe. It seems to have opened up quite an interesting door and also afforded the protection to creditors to know that board of directors can be responsible in case companies do go bankrupt. The impact of this decision was significant. It demonstrated a first reported instance in Dubai courts where board members and directors of a UAE-based company being responsible for the debts of a company. And it has severe personal consequences. There's severe personal consequences for board of directors and managers acting on behalf of companies. From a recognition and enforcement perspective, it is likely that we'll see further developments on the case because the parties have the right to appeal the judgment for the Dubai courts and Court of Appeal, and we're yet to see what happens then. I will turn now to the recognition and enforcement onshore, which is the UAE courts, not ADGM or DIFC. Importantly, an area which does not appear to be addressed by the laws onshore is the enforcement of foreign proceedings. The UAE has not particularly adopted the UNCITRAL model, law on cross-border insolvency, and there's no express provisions that are found in the law dealing with the recognition of foreign insolvency proceedings as distinct from any other type of proceedings. It therefore appears that such proceedings are treated as ordinary judgments onshore and will need to be subject to the same recognition and enforcement procedures. In this respect, it appears that the special streamlined procedures would apply to recognition of DIFC insolvency proceedings onshore in Dubai and ADGM insolvency proceedings in Abu Dhabi in the ordinary way. However, from my experience, I've found that the courts have previously recognized the authority of liquidators to represent foreign companies that are under liquidations. I've had many cases actually where a foreign entity was represented by a liquidator. At the time, the foreign entity was under liquidation, and therefore we were able to recognize his authority to represent the company and continue the case and represent lawyers to defend or claim before the Dubai courts. So it's very important that that authority can be demonstrated to the courts. There's no special regime, though, to assist foreign insolvency actions. However, the liquidator would have all the rights to raise cases against debtors or defend cases against creditors. And he can, the authority will allow him to act and also represent the company. Alex, I'll turn to Alex to speak about some of the cases.
Thank you, Hamdan. I just wanted to talk a bit about one recent decision of the DIFC court, which shows that recognition in the offshore courts isn't always straightforward. This is the case of Salim Mohammed Balama Al-Tamimi and others against Emirates NDB Bank, which was decided last year by Justice Sir Jeremy Cook. Now, what happened in that case was that restructuring proceedings had been commenced in the Abu Dhabi courts by an individual debtor, together with several companies whose assets overlapped with the individual debtors in a way which was hard to desegregate, as permitted by the UAE bankruptcy law. Now, the Abu Dhabi trustees then brought a claim in the DIFC courts, requesting recognition of the Abu Dhabi proceedings as foreign main proceedings under the DIFC insolvency law. And the purpose of that claim was to stay proceedings that had been brought by creditors of the individual debtor in the DIFC courts. And those creditors were pushing for enforcement action against the individual debtor in respect of personal guarantees that he'd given. And what the trustees were seeking from the DIFC courts were orders recognizing and enforcing the commencement order made by the Abu Dhabi courts, and also staying proceedings in the DIFC against the individual debtor and the joined litigants. Now, unfortunately for the trustees, the application was refused on the basis that it didn't satisfy the requirements of the UNCITRAL model law. In particular, the model law defines a foreign representative as someone who's authorized to administer the reorganization or liquidation of the debtor's assets or affairs. Now, the judge looked in this case at the terms of the Abu Dhabi court's commencement order and concluded that no order to such an effect had actually been made. Rather, the trustees' function under the Abu Dhabi court's order was merely preparatory in nature, and it was limited to putting forward proposals for restructuring for the approval of the creditors or the Abu Dhabi court. The role didn't extend to actually administering any reorganization or liquidation, and so the trustees weren't foreign representatives as defined under the model law. The problems unfortunately didn't end there, though. Another difficulty was the fact that under the DIFC insolvency law, the UNCITRAL model law only has force in respect of foreign companies. So the court concluded that the operation of the model law didn't apply to an individual debtor at all. So what about the other joint litigants who were companies? Well, the problem here, as the court found, was that those companies hadn't applied to the Abu Dhabi court for the restructuring of their affairs as insolvent debtors, unlike the individual debtor. They'd just been joined because of the overlap of assets. So again, these entities fell outside the terms of the model law for the purposes of foreign proceedings capable of recognition. So what can one take away from this decision? Well, first of all, the case provides an important reminder that not all foreign bankruptcy proceedings will be recognised in the offshore courts of the UAE. And in particular, it's worth remembering that the model law will not permit recognition where an individual commences bankruptcy proceedings before the foreign court. And it also seems that it won't be easy to circumvent that by adding other corporate entities who aren't actually the main debtor. You'll also have to look carefully at the terms of the order made by the foreign court and check that it gives the trustee or foreign representative the power to administer the reorganisation or liquidation of the assets so as to fall within the relevant definition. So we're now going to turn to a number of examples to show how recognition and enforcement might work offshore and onshore. So I propose to hand over to Carl to take us through the first example.
Thanks very much, Alex. So the first example that we're looking at here is the recognition of a foreign insolvency procedure in the DIFC or ADGM. So, for example, an administration in England or something along those lines being recognised in the DIFC or the ADGM. Now, in our view, this example is a fairly straightforward one for the reasons which we've previously discussed, in that both the DIFC and the ADGM adopt the UNCITRAL model law. So in those circumstances, what the foreign office holder can do is apply for recognition in the DIFC or the ADGM and obtain the assistance that we saw before from the offshore courts. Now, the application process itself is relatively straightforward, and the main document that needs to be filed as part of that application is a form of proof of the existence of the foreign insolvency proceedings. And in practice, that usually takes the form of a certified copy of the decision of the foreign court commencing those proceedings. And it's also worth pointing out that as part of that process, both the DIFC and ADGM regulations include an express provision for the application for recognition to be decided at, quote, the earliest possible time. So hopefully in practice, what that means is that the office holder won't have to wait too long after submitting their application before they are able to obtain an order from the DIFC or ADGM courts formally recognising their foreign proceedings as either main proceedings or non-main proceedings, and then they can begin the process of taking advantage of all those advantages we saw before. So that's that example, which is relatively straightforward. I'll now hand over to Zara, who's going to talk about a slightly different example, which is what happens where matters are turned the other way around.
Thank you very much, Carl. I'm going to talk about recognition of a DIFC or ADGM, or indeed onshore insolvency procedure in England and Wales. And similar to the example which Carl looked at, this should also be relatively straightforward, because England and Wales have also adopted the UNCITRAL model law. So the onshore or indeed the offshore office holder can apply for recognition by a relatively straightforward process and hopefully then obtain the benefit of the statutory and common law powers of assistance from the English court. So in theory, it ought to be just as simple as the example which Carl looked at, where you have an insolvency practitioner seeking recognition from the offshore or onshore courts in the Gulf region. I'm now going to pass on to Hamdan, who's going to look at the position onshore.
Thank you, Zara. So with enforcing a insolvency onshore, the issue here is that there's no express provisions providing for that. So really the onshore courts will treat an insolvency of outside the court's jurisdictions as just a liquidator would just represent the company and would act on behalf of the company if he can prove so. What's more interesting is whether they would recognize a DIFC and ADGM insolvency onshore, and what powers, what would they provide in terms of assistance to such insolvency procedures done in the DIFC and the ADGM. That's yet to be discovered, as I don't have any examples of such. But my best guess would be that the onshore courts would allow the liquidator to act on behalf of the ADGM or DIFC company. However, would not necessarily extend all the bankruptcy processes onto the onshore jurisdiction, which include protections like stopping cases and putting a pause on cases until the liquidation process ends. To sum up really everything, the UAE is fast developing rules relating to insolvency and restructuring. I think it is very important because the ever-growing international world we live in sees more and more companies working cross-border. And insolvency, especially after the coronavirus pandemic, have been ordered in few jurisdictions where companies have their branches cross-border. And I think Dubai makes it having good insolvency rules will make it very attractive from the perspective of both insolvency offers holders and unpaid creditors alike. The adoption by the ADGM and DIFC of the UNSU trial model is a very helpful step in cementing those jurisdictions as friendly to foreign insolvency office holders. Presently, the recognition and enforcement of foreign insolvency proceedings take place onshore in a very regular method, in the sense that the insolvency office holder will represent the company without the added protections of the bankruptcy laws, whereby he will just whereby he will represent the company and defend or claim before the Dubai courts. This issue is likely to be clarified as more and more foreign office holders seek to engage help of the onshore courts in the process of managing their insolvency or administration of their debtors. That sums up really the whole webinar and things we wanted to mention in the webinar. And I think it's time if Christina can go to the next page for questions, as mentioned there. So I'll hand over to Christina. Christina, do you want to guide attendees' respective questions?
Guys, could just help me out to read the first question. Is there, because I can't seem to see it, so I don't know if you can read out the first question. Anybody had any questions?
Apologies. Then.
I was doing the screen sharing, so if you don't mind.
I actually didn't notice any questions you had asked.
Just give me a second. Okay. I would like to have a question, actually. I think it's interesting to know. I think it was, thank you very much, everybody. And I think it's really interesting to, to hear the examples of both NMC and Marca. But I think it would be interesting to also just do a comparison. What's the real difference between the onshore and offshore insolvency based on the two cases that you guys presented?
So if I may answer, in summary, the offshore ADGM DIFC jurisdictions recognize foreign insolvency orders, which means that if there's an insolvency happening outside the UAE, they can apply for the DIFC and ADGM for certain protections offered under the bankruptcy laws, which are really the important ones are to pause all claims against the company so that the liquidators can better manage the process of bankruptcy. It is difficult managing the bankruptcy process when you have cases being registered and being heard before courts. It makes everything very complex as well when you're dealing with a company, that deals cross-border and has a lot of branches around the world, to just get everything together and go through the bankruptcy and liquidating job, and then actually liquidating the company. I think that's what the Untitled model seeks to do, to ensure that insolvency can occur cross-border as easy as possible. The onshore doesn't necessarily have that or any express provisions in respect of that. So such protections that I mentioned will not be found onshore. Onshore meaning the UAE courts, excluding DIFC and ADGM. Anybody want to add from the panelists anything?
I was just going to add one thought, which was the distinguishing feature seems really to be mainly the adoption by the offshore courts of the Untitled model law. Obviously, as the effects of the pandemic continue to recede, but one may see an increasing number of insolvencies arising out of it. So it may be that, notwithstanding the onshore courts, the fact that they haven't adopted the model law, if some decisions start to come through where foreign insolvencies have been recognised, then it's possible that a sort of practice for that kind of process to take place will emerge.
Thank you very much. Is there anybody else that would like to add something? I have another question, but I'd like to wait from maybe the audience if you have any questions. Another question would be that what was the main reason in the Marca case that the board of directors and managers were personally liable? I don't know if Hamdan.
That is certainly an interesting case, and I think through this case will offer the business community and creditors alike the trust that in the event companies do not pay and the board of directors violate the law, that they could see their monies being paid back to them, even in an insolvency. In severe really cases, because the condition for that is that the company is unable to pay 20% of its debt, meaning 20 cents to the dollar. So if someone is unable to recover 20 cents to the dollar, and the board of directors have violated certain provisions of the law, they can see themselves being paid their debt in full. So it's a very interesting case with huge ramifications. It can give a lot of trust to creditors, trust that they should trust the systems, trust that companies and board of directors will not get away with it. But it also puts a very scary image in a lot of board of directors, people holding those posts, and it's a big lesson really for them to ensure that they don't fall in this.
Thank you very much. I don't know if everybody was here in the beginning. If you have any questions, please, we would like to receive them on the chat, so we can read them out loud. If not, then we will be ending the webinar. I think it was very useful and very, very interesting. I would like to wait a couple of seconds. Maybe there is some questions formed, and then after that end the webinar. So thank you, guys. I don't seem to see anybody asking anything. If anybody has any further questions, I have included the email previously, where you can find us there. Please ask anything you wish. So thank you very much, everybody, and have a good day.
Thank you, Christina. Thank you to the panelists.
Thank you.
Thanks, everyone.
Thank you.
Thank you.